I want to talk a little bit about the traps and loopholes in international IP law. I'm an IP lawyer based in Hamburg, but in a law firm that has offices around the world. We are about 2,500 lawyers. So we are always dealing with IP transactions throughout the whole world. And I see some misconceptions from producers and game developers, publishers that always come up in my work, and I would like to talk about them a little and how I can avoid that. The problem we have is that all game developers are thinking globally. The whole world is reachable, where we are all platforms, and you're all thinking about doing your games for every country in the world. But we lawyers are always a little bit behind, and we are still thinking in local laws. It's every country does what the country wants to do, and we only have very little harmonization around the world, and it's not always the same. And that's a little problem. Before I talk about the problems of the local laws, I want to get rid of some misconceptions of the different IP laws that we have, that I always encounter. We have trademark rights. Trademark rights only protect signs and words that identify products from other products. And that's the only thing a trademark protects. So if I name my brand Rovio, it indicates that all the products with this name come from the company Rovio. And that's what's behind trademarks. That's quite different to copyrights, because they protect the creative work. They protect art, literature, characters, game design, arts, whatever you can think about, and it's the creative work that's protected. So however I use that creative work, that might amount to a violation of copyright law. Whereas that's not true for all trademarks that I use for different stuff. And then we have a third one that's not really well known. That's somewhere in between. That's industrial design. That's mostly a registered right, similar to trademarks. I can register novel designs that I do, for example, the candy in certain candy games. The single pieces you could register as an industrial design if they are new and novel. And then you have a right that's quite similar to trademark, but it's more like protecting how it looks. And that's an industrial design. So it's important to know that they are different rights because you get them in different ways and they protect different stuff. So now let's go to globalization. We have, first I'm talking about trademarks. There are basically 3 different types of trademarks if you look from a European perspective. You have national trademark rights. That's trademark rights that only are registered in one country, and they only protect you in that country. If you have a national trademark in Germany, it doesn't help you if someone in the US uses that trademark. You can't do anything about it. It's your German trademark, only protects in Germany. Then we have European Union trademarks. They were called community trademarks until the mid of last year. Now they are called EU trademarks. They have a protection for the whole of the European Union. They basically work like a national trademark for all 28 countries. It's one right, protects you everywhere here. And then lastly, we have international registration. That's merely a way to apply for national trademarks. If you know that you want to use the mark in 50 different countries, and you don't want to go to every country and apply there, and then you have to make translations for every country, and you have to pay the fees in every country, and some countries may be really difficult, and you didn't even know that you can apply for trademarks in North Korea. You can opt for an international registration. For that, you need a national registration, for example, in Germany. And then you go to the German trademark office and say, well, now I also want trademarks in this 50 other countries. Do that for me. And then there's an international system with the WIPO, World International Property Organization, where the national trademark office will send this trademark application to the WIPO, and the WIPO will send it to the national trademark offices, and they do all the stuff for you. You have to pay for every country for which you want to do that, but it's a lot less work than going there yourself, and you don't have to make the translations. What's also important for the international registrations is normally trademarks work with a priority. First come, first serve. You register your right, and all the people that come after you are shit out of luck. So if you start your game in one country and you're not really sure whether it's going to be a big one or not, and you don't want to spend the money right away to get trademarks in all countries, you could just start in one country, apply for a national trademark there, and then you have 6 months time to decide whether you want to have an international registration. And within this 6 months, if you file the international registration, the priority date from your first trademark will apply. So it will look like you had a trademark dating to the 1st of January in all 50 countries, even so you only applied for 49 of them on the end of June. So that's the good thing about international registrations if you want to go to many countries. That's a lot of text there. Just 3 things that you should think about before registering a trademark. Are you already using the sign? There are a lot of countries in the world where you don't have to use the sign to get a trademark. But for example, in the United States, you have to have already proof of use. So you have to have started using the sign before you can get a trademark. That's a totally different approach. We in Germany, you can apply for a trademark and you don't have to use it for 5 years. So that's quite different. So maybe you want to start in a country like Germany where you don't have to file proof of use and then do an international registration later on for the US when you have started using the sign. Then, is the sign descriptive in some languages? I'm not sure who of you is German. In German, we talk about our little smartphones. They are called Handy. That's a very German word for a mobile phone. In Germany, it would be really difficult to get a trademark registration for Handy for mobile games because it's the name of the device you're playing on. But in other countries, it might well be possible because no one else is handy to their mobile phones. So you couldn't get a trademark for that in Germany, but you could get a trademark for that in many other countries. So think about it, where you can apply for the trademark. What's especially important for European Union trademarks, the fact that it's descriptive in Germany is enough to destroy the European Union trademark. So don't apply for a handy trademark in the European Union because it's descriptive in Germany, but you can apply for it in, I think, about 20 other countries of the European Union and it would work. Yeah, and the last one I already touched about, if you're thinking about expanding to other countries but are not really sure about it, think about an international registration first. That's the most important parts about trademarks. Trademarks are registered rights. That's very clear what they protect, how they work, what you can do. You're now going to copyright, which is a lot more difficult and a lot more different in the different countries. This is Naruto. I'm not sure whether you know him. He made this photo of himself, and PETA, the animal rights organization, tried to sue users of this photograph, stating that, well, you violate his copyright if you use that picture. And I can tell you they lost in the United States, and they would have lost in nearly all countries in the world, because copyright only applies to works that were made by a human. So Naruto doesn't have a copyright to this picture, so you can use him. I can use him here. I really like that one. What you need for a copyright-protected world, nearly everywhere in the world, is a personal intellectual creation, something creative. It doesn't have to be art. It can be a lot less than art, and art is always in the eye of the beholder, you never know. But it must reach a level of creativity. And then there come the differences in the different countries. There are countries in the world, for example, the United Kingdom, they have a list of works that can be protected. So if you invent something completely new, for example, a VR experience that cannot be titled as a video and not really as a computer game because it's somewhere in between, you might be hard-pressed to get a copyright because it's not in the list of works that can be protected by copyright. In most of the countries in the world, they don't have such a strict list. It just needs to be creative, and then you can get it even if it's something completely new, if you've no idea what you can invent, but there might be completely new art stuff and you still get copyright for it. How do you get a copyright? That's really important nearly everywhere in the world, in all blue countries in the world. They are member states of the Berne Convention. And this means that you get the copyright just with the creation of the work. You don't need a registration. It's not necessary. You don't have to put the C in the round thing to get the copyright. Just by creating the work, you are protected. With one exception, in the United States, you still are protected. You do have the copyright. But if you publish the work in the United States as a first thing, the first time it's ever published, you need to register the copyright to get certain procedural rights. You can't sue for copyright, or only under really difficult circumstances, if you don't have the copyright registered. So they tried to circumvent this Berne Convention with this. They wanted to sign it. They were really late to the party. The Berne Convention is from 1890, so more than 100 years old, and the United States got to it in about 1990, and just because they wanted to keep their registration requirement. So now, another difficult thing is the principle of territoriality applies nearly everywhere in the world to copyright. That means if you have a copyright, you always have to look at the national law of the country to which you want to get some rights out of the copyright to see whether you have the rights. So I made this big movie in the United States, and then someone here in Germany is downloading it or copying it and selling it on DVDs in Germany. Then only German copyright law applies to me getting after the pirate. That's really, really important because we have two very different copyright ideas in the world. On the one hand, we have the real copyright, protection of the work. In this system, we look a lot of the material value of the work, and we protect the work. And you can give the copyright to someone else. You can completely get rid of the copyright if you're the creator. And that's quite different to the system we have in Germany and France and a lot of continental Europe, where the copyright does not protect the work, but the author and his connection to the work. This means that in countries like Germany, you can't get rid of your copyright. If you are the creator of the work, you can do whatever you want. The only way to get rid of your copyright is to die. You keep it. You can give licenses to other people. That's how it works here. You can give exclusive licenses. You can give such exclusive licenses that you are no longer allowed to use the work yourself. I know that. It's happening if you write books. You don't have any rights left, any marketing rights. But what you always keep are the moral rights. And we have very strong moral rights in continental Europe. We don't have them so much in the United States. We do have them there, but very, very basic ones. What is a moral right? That means that other people, even if they have exclusive licenses to my work, can't use the work however they want. They can't use it in a way that would destroy my reputation or would put the work in a light that I don't want to have it. For example, play music at the party convention, political party that I really don't like and that's way out of the normal spectrum. I can always go after such violations, even if I've granted all my rights, all my marketable rights, to someone else. And that leads to one interesting problem that I have nearly daily in my work. Companies that work mainly in the US or in some other countries rely heavily on this work made for hire principle. That means if you have created a work as an employee in the United States, the copyright doesn't exist in the author, in the creator, but in the company for which you've worked with your employer. And it's really the copyright that has moved from the creator to the company. And that's something we don't accept in Germany. That means that you have made this game and you have 20, 30 people that worked on it and created something creative in this game. And you come to Germany because in Germany someone downloaded your game illegally, copied it, used graphics of the game for another game. And you can't sue. Because you can't prove that you have the license to the game as a game company. Because you always thought, well, that was my employer in the United States. I just got this copyright, it's now with me. But in Germany, I have to show a license chain. I have to show that I have the license to use this game and to sue from this game. And United States companies don't have that. And then we have to fake it. That's not really cool and it's really difficult and does not really work. How you get around it? It's quite simple. It would suffice if every one of your employees just signed a single line, even that would be better than nothing, stating that hereby I grant all the rights to the work I do at Game XY to my employer. And that would get around the problem of the work made for hire principle in countries like Germany. That's one of the most important traps I find in my daily works because nobody thinks about that. And we have real problems with that. And that's already what I wanted to tell you. That's the two main things. Trademarks, think about where you want to register them. Is the term descriptive or not? Do I want to expand or not? And copyrights, always the national law applies. And you can't get rid of your copyright in Germany. So, any questions?
So maybe one question then from this side. So we have seen kind of the foundations of the different ways to protect our intellectual property rights and also to getting the licensing, what could be possible caveats. Just out of curiosity, because we have had quite a number of Indian smaller developers here, how does actually the enforcement side goes? Because of course, if we are thinking about more kind of the smaller companies, they might not have the sufficient funds and essentially the power behind them to really go and chase it down. What would be your recommendation? How would a smaller company be able to essentially exercise these rights that they have invested money, time, and effort to obtaining?
That's a really good question, especially if you come from another background, not from a German one. It's quite cheap in comparison to sue in Germany. We are not suing as much as the United States, but it's a lot cheaper. And if you win, you get at least a part of the lawyer's fees back, and you get the court costs back. That's also different to the United States. And we have a very, very powerful method in Germany. And that's also very, very dangerous if you use content of someone else in Germany. We have a system for preliminary injunctions. There are similar systems around the world and in Europe, but in Germany it's especially sharp, because you apply at a court for a preliminary injunction stating that I want the court to order that this company ceases to use this trademark, this copyright, this thing immediately. If they don't, if they continue to use it, they have to pay up to 250,000 euros as a contractual penalty. And you go with that to a court, and they decide in 2 or 3 days for a preliminary injunction with which you can stop the use of the trademark or content in the whole of Germany immediately, without an oral hearing or any kind of hearing of the other side. So you can't really defend yourself. If you know that you have maybe a problem, you can file a brief in defense before the preliminary injunction brief is filed, but that's not really working, because you would have to know exactly what the other side is going to say, why you violate it's not really working, but you could do that. And then you have, as the claimant, this preliminary injunction, and you can go around and say, well, don't do that anymore from this moment on. And then you have to suspend your game from the app shops at this moment as soon as it's humanly possible for you, because if you don't do it, you have to pay. And then you can file an opposition against this preliminary injunction, but that takes a while, 2 or 3 weeks at the minimum, at the bare minimum. So, yeah, we can get rid of violating content quite cheaply and quite fast in Germany. And that doesn't cost much. I think about 5,000 euros, and you have that for the whole of Germany. If you have a European Union trademark, you can go to a German court and get rid of that for the whole of the European Union with a preliminary injunction. Thank you.